Hey everyone, welcome to another episode of the Ask Amity Show. And today we want to talk about who can be the personal representative in a probate case. So a person named as the executor in a person's will in California has the right to be appointed as the personal representative unless they are otherwise disqualified. So what happens if the nominated personal representative does not want to serve? Well, they can simply decline. They're not required to serve just because they've been nominated. What happens if someone doesn't want to be the personal representative? Well, the priority of the appointment of the personal representative is set forth in the California Probate Code, and the following order of priority for entitlement to the appointment is as follows. So first is surviving spouse or domestic partner as defined in Probate Code, then children, then grandchildren, then any other issue, then parents, and then if parents don't want to serve, then brothers and sisters, and then the children of brothers and sisters. If that doesn't work, then grandparents, and then the issue of grandparents. And then it goes down further to children of a predeceased spouse or domestic partner, or other issue of a predeceased spouse or domestic partner, other next of kin, parents of a predeceased spouse or domestic partner, issue of parents of a predeceased spouse or domestic partner. You can also have the conservator or the guardian of the estate acting in that capacity at the time of the death, who has filed a first account and is not acting as a conservator or guardian of any other person, a public administrator, and then finally creditors. Creditors can also initiate probate and be the personal representative for the estate that they are trying to collect their debt on.
Yeah, and then there are some exceptions to this order of priority, primarily in regards to the surviving spouse or the domestic partner's priority to serve. So if the surviving spouse or domestic partner is entitled to succeed to all or part of the estate, or takes under the will, or is entitled to succeed all or part of the estate of another decedent who is entitled to succeed all or part of the decedent's estate, then the surviving spouse or domestic partner maintains priority to serve as administrator. However, if the surviving spouse is a party to an action for separate maintenance, annulment, or dissolution of marriage and was living apart from the decedent when the decedent died, then the surviving spouse has priority after the brothers and sisters and not the priority as set forth previously. So if they were in the midst of separating, living apart, filing for divorce, annulment, then that priority kind of shifts to after the brother and sisters of the decedent.
So who is prohibited from being a personal rep in California? Sometimes a person is not competent to serve as a personal rep in California because they are disqualified by statute. So under the California Probate Code, a person is not competent to serve as a personal representative if the person is not of the age of majority. So they're a minor, they can't serve as a personal rep. The person is subject to a conservatorship of the estate or is otherwise incapable of executing or is otherwise unfit to execute the duties of the office. If grounds of removal of the person from office under California Code exists, the person is not a resident of the United States, and the person is a surviving partner of the decedent, and an interested person objects to the appointment. Provisions for a non-resident and surviving partner prohibitions do not apply if the person is named as the executor in the will.
Does a personal representative named in a will have power before the appointment? Generally speaking, the answer is no. The person must be appointed by the probate court as a personal representative and letters issued for the appointment as personal representative to be effective. The person named in the will to serve as personal representative can pay for funeral expenses and take necessary steps to maintain and preserve the estate prior to the appointment being made effective. Probate, it's a very complicated process. We'd be happy to talk to you about this process and kind of determine who has a priority to act as a personal representative for the estate. Again, thank you for watching and feel free to subscribe to our channel. We'll talk to you next time. Bye-bye.